Did I understand your ladyship to be indicating that you'd like me to go directly to the history rather than continuing with the summary?
No, you were to come up with a perfect sentence in answer to my Lord Hughes' question.
Yes, that was what you were principally.
Oh, yes. Well,
I doubted it was that significant, Mr. Fitzgerald.
More than 140 characters. So.
Well, can I just indicate that, perhaps before going back, that the issue of what the common law prohibition was and its extent is dealt with if I can just give the court at part 6 of our so we say that of our summary in the speaking note, there's a detailed analysis of statutory developments in the UK during the 19th and 20th centuries, paragraphs 43 to 63 of the case. And that shows the prohibition on the execution of the insane was the principle of law, and that those shown to be of unsound mind at the time of sentence were entitled to a reprieve and consequently to a pardon ex necessitate legis. Then to give effect to that principle that they're bound to grant a reprieve, we've set out 6.2. Chitty, in his practical treatise on the criminal law, states that the other cause for which the judge is bound to grant a reprieve is the insanity of the prisoner. That's volume 8, tab 128, 3280 in the electronic bundle. And so at 3280, one sees Chitty on pardons. The other cause for which the judge is bound to grant a reprieve is the insanity of the prisoner. Has from the earliest periods been a rule, though a man is in the full possession of his senses when he commits a capital offence, if he becomes non-compos after it, he shall not be indicted. If after indictment, he shall not be convicted.
Sorry, which page are you reading from?
It's page 3280.
3280, thank you. Yeah.
So it's the top of page 3280. So the other cause for which the judge is bound to grant a reprieve is the insanity of the prisoner. Has from the earliest periods been a rule that though a man be in full possession of his senses when he commits a capital offence, if he becomes non-compos after it, he shall not be indicted. If after indictment, he shall not be convicted. If after conviction, he shall not receive judgment. If after judgment, he shall not be ordered for execution. And this opinion is confirmed by the fact the statute was passed in the reign of Henry VIII to allow of execution of persons convicted of high treason, though insane, which was always thought cruel and inhuman, was repealed in the reign of Philip and Mary. The true reason of this lenity is not that a man who has become insane is not a fit object of example, though this might be urged in his favour, but that he is incapable of saying anything in bar of execution or assigning any error in the judgment. The judge may, if he pleases, swear a jury to inquire ex officio whether the prisoner is really insane or merely counterfeit, and if they found the former, he is bound to reprieve him till the ensuing session. So that's the mandatory inquiry after judgment, which would permit a reprieve. And then he says it's a matter of course and not a favour at, if we go over to page 3282, he says, this at the bottom of page 3282, this prerogative of pardon is in general a matter of pure discretion, but there are certain cases where he is bound to allow it, and the grant is a matter of course and not of favour. And that appears to be one of them where that the person is found to be of unsound mind, although he then goes on to deal with various of them after that. And then Blackstone, which we summarise at 6.2 of the note, Blackstone is volume 8, tab 135, and can I take the board to page 3337?
Well, luckily, that's any legible page in my copy.
Yes, well, Yes. The second case of a deficiency in will, which excuses from the guilt of crime, arises also from a defective or vitiated understanding, viz. An idiot or a lunatic. For the rule of law, as to the latter, which may be easily be adapted also to the former, is that furiosus furore solum punitor. Actually, I've always thought it was furore ipso punitor, but anyway. In criminal cases, therefore, idiots and lunatics are not chargeable for their own acts, if committed when under these incapacities, no, not even for treason itself. Also, if a man is in his sound memory, commits a capital offence, and before arraignment for it, he becomes mad, he ought not to be arraigned for it, because he is not able to plead to it with the advice and caution that he ought. If after he has pleaded the prisoner becomes mad, he shall not be tried, for how can he make his defence? If after he be tried and found guilty, he loses his senses before judgment, judgment shall not be pronounced. And if after judgment he becomes of non-sane memory, execution shall be stayed. For peradventure, says the humanity of the English law, had the prisoner been of sound memory, he might have alleged something, I'm afraid we do have to go in stay of judgment or execution.
Now, is it the judge who resolves all these issues if there is an issue?
Yes.
Including at the last stage, or not?
No. My lord, before judgment, and if after judgment he becomes yes, it should be stayed by the judge, yes. Yes, so that's up to stayed, yes, all of those are decided by, I'm so sorry, all of those are decided by the judge, yes.
So throughout, on this analysis anyway, throughout it's a judicial process.
Yes.
It isn't part of the
that's right.
The executive's prerogative, which is something different.
That's absolutely right. And my lord, you've seen that that in Chitty they're saying you could actually swear a jury to determine whether the person who becomes insane after judgment. And Blackstone says the same thing. If we read on, it deals with Henry VIII's bloody reign, and but if there's any doubt whether the party be compos or not, about 15 lines down, this shall be tried by a jury, and if he be found a total idiocy or absolute insanity, excuses from the guilt and of course from the punishment of any criminal action. But if a lunatic have lucid intervals, it shall answer for what he does in those intervals as if he had the deficiency.
If the rationale of these is as stated by both Chitty and Blackstone, then at that stage, which admittedly is a very long time ago, the sense of it was that he couldn't take part in the proceedings. It's unfitness to plead, isn't it?
Yeah, well, it's that.
I mean, it doesn't appear to be just any mental abnormality at any rate.
It's that he might, both of those refer to the fact that he might say something in arrested judgment. I have to accept that they both say that. But it clearly, in the case of Blackstone, covers both idiocy and lunacy. And I mean, broadly, if one's trying to, although they shade into one another, idiocy being mental handicap and lunacy being seeing things and hearing things. I mean, but in Trinidad, from the end of the 19th century, the Lunatics Act talked in terms of mental idiocy or other mental unsoundness. So they treated idiocy as a form of mental unsoundness. So that's really the notion that there had to be some judicial consideration is present there. And can I just show the board the further matters that we refer to in 6.3? It's also now clear that the practice in both England and Trinidad... Oh, yes, sorry, I should show you one more thing. Volume 9, there's an Archbold, which is 1961, Volume 9, tab 164. And so this is post the 1957 Act. Page 4128. Under the heading reprieve at the bottom of 4128, a reprieve is the withdrawal of the sentence for an interval of time whereby the execution of it is suspended, and it may be granted either by the Crown or by the court empowered to award the execution. A reprieve is grantable by the Crown ex mandato regis at its mere discretion, is grantable by the court ex arbitrio judiciis at its discretion whenever substantial justice requires it, or ex necessitate legis. As to reprieve in capital cases, see the Judgment of Death Act 1823, the judge of assizes have power of reprieve after their commission is determined, though the continuance of this power is said to be rather of common usage than strict right, and then it refers to Hale and Hawkins. The court is bound ex necessitate legis to grant a reprieve where the prisoner becomes insane after judgment pronounced against him. So there's there saying that the judicial duty to inquire, and if they find insanity, to grant a reprieve, appears to have been considered to have endured right through the 19th century into 1961. And even after the diminished responsibility was introduced. So, ladies and my lords, we obviously accept that this is premised on insanity, but the notion that there is a quality of unsoundness of mind that justifies judicial intervention and judicial fact-finding, even after conviction, so as to stop execution, is there in Chitty, in Blackstone, and in Archbold in 1961. So there's nothing inimical to the whole approach of the common law in saying a judge, after the conviction, should inquire into the mental soundness of the person to see whether they should undergo the death penalty, or to stop the undergoing of the death penalty. Now, and in my lords, there is a passage from the Atkin Committee on Insanity, which we have over there, but which helpfully summarises the position. Unfortunately, we didn't have this until Friday. We cited in the supplementary case. But it is quite helpful in the sense that it summarises the position in a couple of pages. If I can take the board to page 16 of the so there it says, top of page 16, there is authority of some weight from the time of Lord Cook for considering that apart from statutory provisions it was contrary to common law to execute an insane criminal. And then it cites Cook, further provided the said Act of Henry VIII that if a man attainted of treason become mad, and then one has the bit which cruel and inhuman law lived not long but was repealed. But so it is not when a madman is executed, but should be a miserable spectacle, both against law and of extreme inhumanity. So it's on grounds of cruelty there. And then Hale, if a man in his sound memory commits a capital offence and after judgment becomes of non-sane memory, his execution shall be spared. And that obviously can be by the judge. Sergeant Hawkins, and it seems agreed at this duty that if one has committed a capital offence, becomes non-compost before conviction, he shall not be arraigned, and if after conviction, that he shall not be executed. Blackstone, and then one sees another case of regular reprise, if the offender becomes non-compost between judgment and award of, as was formerly observed, though a man be compost when he commits a capital crime, yet if he becomes non-compost after judgment, he shall not be ordered for execution. So John Hall's, nothing is more certain that a person who falls mad after a crime committed shall not be tried for it. If he falls mad after judgment, he shall not be executed. He adds that it would be inconsistent with humanity and inconsistent with religion to make examples of such persons as being against Christian charity to send a great offender, quick, as it is styled, into another world when he is not of a capacity to fit himself for it. And then Stephen, in his commentaries, quotes and adopts the above dicta of Cook, Hale and Blackstone. And then this is what the Atkin Committee says, and they're writing in 1929, I think it is.
23.
No, sorry, 1924. Okay, George V. Probably these authorities have influenced the practice of successive Home Secretaries, but since the Act of 1840, we have indisputable authority for saying that no prisoner under sentence of death has ever been executed as to whom a certificate of insanity has been given under the statute for the time being enforced.
Now, these all assume or some insanity, as it were, insanity properly so called, as it were.
Yes.
In fact, your principle is a great deal wider than that, isn't it?
Yes, my lord, we say the principle has always applied to both insanity and idiocy, if I can call it that, and indeed an extreme form of idiocy might well qualify under insanity.
Well, I think it can readily be traced back to all sorts of areas of the law where idiocy was regarded as a species of being of unsound mind.
Yeah, absolutely.
And you can find that in the early lunacy legislation in the 19th century, and you can find it in the common law relating to, I suppose it's the common law, but anyway, the royal prerogative relating to persons of unsound mind encompass both idiots and lunatics. So they have been equated.
Absolutely. As long as if I can put it bluntly, as long as the idiocy is severe enough, it's treated as the same.
Oh, absolutely, and
yes.
of course.
But that's a starting point. The question is the Trojan horse that gets us beyond existing laws? If there is, then it's capable of development, and we say that there is. What we respectfully submit is that statement. So the statement of the Atkins Committee is helpful. You have then there's the express provision inserted by Section 4 of the 1946 Ordinance in Trinidad that the governor shall commute the death sentence of anyone certified as of unsound mind. I think we have the 1946 Ordinance there, which we put in our postscript to the supplementary case. Oh yeah, we will produce these in an electronic supplementary bundle. Thank you.
So thus, I think, getting us something like 6 electronic...
Oh, far more than that.
Lots more than that.
Well, obviously the issues are somewhat difficult one to find materials in relation to, and it would take us some time to find them.
Right.
Absolutely. Yeah.
If they could all be converged into a single PDF, that would be,
My lord, it will be. Yeah,
I think, less than wonderful.
my learning from Mr. Bone is a technological whiz, and we'll.
Well, we look forward to testimony of that.
Yes. The 1946 Ordinance. So that is so in Trinidad we just have shall suffer death as a felon, and nothing about pronouncing sentence. But then we have the provision of the 46 Ordinance, which unfortunately is saying insert something into an earlier ordinance, which we have not yet found. But I can take you to Section 6 of the Lunacy and Mental Treatment Act, and it's at page 111.
Of?
This thing here.
Yep.
Yeah, so it's page 111 of the 1936 Ordinance. And then it says, Section 28 of the Principal Ordinance is repealed and replaced by the following. 28.1, where the governor is satisfied that any person imprisoned for any cause is of unsound mind. Now, unsoundness of mind includes idiocy there, and it has done since 1877 in the Trinidad legislation.
Defined in terms of justifying confinement, isn't it?
Yes. So that's why we've used the expression in the case unsound mind, because it straddles idiocy and mental illness, if I can call it that, sort of seeing things in here, sort of Hadfield's problem. Or where it is represented to the governor that any such person appears to be of unsound mind, the governor may, by warrant under his hand, direct such a person be removed to such criminal lunatic hospital or colonial mental hospital as the governor thinks proper. He be detained in such until discharge. And then, can I take you to 2B? If such, so it deals with the case where someone is under sentence of death, and if such person still remains liable to imprisonment or other sentence, he can be removed to the appropriate prison or place to undergo such sentence, etc. And then the proviso to B, provided that if such person is under sentence of death, which has not been commuted, such sentence shall not be carried out if the principal medical officer certified such person has been of unsound mind at any time subsequent to the passing of the sentence. In such case, the governor shall commute such sentence. So by 46, if you're of unsound mind, there's a mandatory duty to commute the sentence. And unsoundness of mind certainly includes idiocy or mental handicap. And it's a mandatory duty. Now, that hasn't been reenacted in the 1976 Mental Health Act, 1975 Mental Health Act, which is, I don't know whether the board has that, but that provision was the law. That was the law in 1961. Sorry, and in 1962 when the Independence Ordinance comes into effect.
Thanks very much.
So one can say that there was a common law understanding that those suffering from either idiocy or insanity, and therefore of unsound mind, could not be executed, which had developed to the point that they should be reprieved by the judge if that became apparent, and then automatically by operation of law commuted, or if it went by the route of medical certification, that if the medical certificate was issued that they're of unsound mind, again, they had to be reprieved. So there is a prohibition in place on execution of those of unsound mind, and that's given effect to in various ways, one of which is the judicial reprieve followed by pardon.
I mean, is there anything relevant? Have we got the Mental Health Act just to show there's nothing relevant in it? Or?
Yeah. Well, it doesn't reenact that provision, my lord. So from 1975 onwards, that proviso simply isn't reenacted.
But was this may be a bit of archaeology that isn't worth trying to track down, but it's very notable that the 1975 Act just has one section about admission by order of a court, which does not look, at very first glance, enough to do the business of the relevant part of the English Mental Health Act that deals with hospital orders, restriction orders, and the like. It looks as if it's referring to other powers.
Like Section 47.
Yes.
The old.
Other sort of powers under what used to be the Criminal Lunatics Act in this country.
Yes.
And one rather suspects that the ordinance we were talking about was the equivalent and gave equivalent powers without knowing that.
Yes.
So I'm just wondering whether you might find it was still there.
Yeah. Yes. Well,
in some shape or form.
Yeah, we are trying to track that down.
But you might not.
No, well, my lady, we will try and track that. And Mr. Persad, who's here, is going to try and. In fact, I think he is also trying to get it tracked down. So, that's the position. So, if just at 6.4 we say this shows the invariable practice was to give effect to an absolute prohibition on the execution, yes, of those certified as of unsound mind. Yes, and the Royal Commission report, the 1953 Royal Commission report, it's at, volume 8, isn't it?
It's volume 8, it's tab 145.
Tab 145, the Royal Commission at page.
Page 3582 to 3.
3582 to 3, that one sees
Paragraph 460.
yes, page. Yeah, no, it's 3583. 3584.
Yes, top of 83.
3583. As the instance of the Home Secretary, we have considered a somewhat technical question, procedure which arises if a person convicted of murder is certified insane. In case a person is reprieved on grounds other than insanity, the formal instrument of reprieve is a conditional pardon granted by the Crown commuting the death sentence to life imprisonment. Formerly, this was done also in the case of persons found insane after sentence of death. I think that must be the judicial finding. But it was discontinued in 1879. The present practice in such cases is for the sentence of death to be respited until further signification of Her Majesty's pleasure. And then one sees the various provisions, but perhaps the most important thing is at the bottom of 3583. If a prisoner under sentence of death is certified insane and removed to Broadmoor, it is unthinkable that the sentence should ever be carried out in the event of his recovery. It's undesirable he should remain subject to a respited sentence of death, in however technical a sense, for an indefinite period, possibly for the remainder of his life. And there's no reason to suppose, well, in fact, we can see from the provisions of the 1946 Trinidad ordinance that was the position in Trinidad too.
Interestingly, paragraphs 336 through to 339 on pages 3543 to 4 contain the Commission's discussion of what they meant, or what was generally meant in those days by mental deficiency. They're classified into 4 categories in 337.
Yes.
And in paragraph 339, somebody with an IQ below 70, yes, but for 338, 339, somebody with an IQ below 70 came into the classification of feeble-minded.
Yes.
They had 3 categories, well, 4 categories. They had feeble-minded, they had imbeciles, and they had idiots.
Yes.
Under the Mental Deficiency Acts.
Yes, I'm right. Well,
This is all perfectly well known.
yes, yes.
At least to Mr. Bowen and me.
Yes. Well, my lady, that's absolutely right. But the position is, of course, that we submit that once it's recognised that the category of idiocy justified the disapplication of the death penalty, then it's a norm that is capable of evolution.
Is there a minimal, or was there a minimum age at which you could be executed?
8.
8.
And then I think it was extended to 10. And then...
I only ask that because...
And then to 14.
Feeble-mindedness
Yes.
is defined as somebody with a mental age of 6 to 10.5 or 11.
Yes. Yes. So, well, at common law it was 8, then it and then it went up to, I think, 10. Yes. So that of course there's the question of yes. In one of these commentators, they say that the age of discretion is whether they have the mental capacities of someone under 14 or not. So that would be very generous to the feeble-minded, if I can put it that way. Oh, yes. It was in 1908, the execution of children under 18 was abolished. Under 16 was abolished, and then it was 18 in
1933.
1933 it was extended to...
Sorry, say that again.
So, in 1908,
Yeah.
execution, it's in the case of paragraph 47.
It's page 680.
Yeah, page 680. Yeah, okay. So page 60 in the electronic bundle.
680.
Yes, 680. You've got the position on. So at common law, it was a very broad definition, but one can see that at halfway down, in 1908, the execution of children under the age of 16 was abolished, and that was raised to 18 in 1933. But that was by statutory intervention. I suppose the real point is, had there not been statutory intervention, it may well be that the common law prohibition would have developed like many other common law prohibitions, and we would. It's clear that the judicial reprieve power remained as something referred to by Archbold as late as 1961, but in effect and in practice, the procedure of statutory certification and therefore exemption from the death penalty was the more usual course, whereby those suffering from any significant form of unsoundness of mind were exempted from the death penalty. And Nigel Walker in his book Crime and Insanity in England and Wales shows how effectively the statutory certification procedure took over as the way for exempting from the death penalty. So, paragraph 3.5. Yes. My lady, my lords, if I can then go back to the ambit of the exception capable of development at 2.7, we submit that the ambit, so once it's acknowledged that there is an exception in the case of those of unsound mind, then we submit that the ambit of the prohibition on execution and of the basic right not to be executed if one is suffering from any form of mental disorder, which would render the execution cruel and unusual, is something that is capable of development. And such development is necessary to give effect to evolving standards of decency and advances in psychiatric understanding. And the board has that. The relevant authorities are set out in the appellant's case. And we refer the board to the Ray's case as to the need for there to be evolution. And against that background, we submit that the exception should now extend to those suffering from a recognised form of intellectual disability. That's to say, one that falls within internationally accepted criteria for the diagnosis of such disability.
Now, where are we going to get those from? I mean, all you have to do for the present purposes is to deal with people with low IQ, but
yes,
there may be a more general proposition.
You mean as to depression and conditions as such?
Well, all the various diagnosable conditions in ICD-10 and DSM-4, for example.
Yes.
Yes, and in that context, we don't need to turn it up, but the Gower Commission was concerned, paragraph 353, not to introduce provisions which would treat mental defectives who commit murder too favourably in comparison with persons suffering from other forms of mental abnormality. So they clearly recognise that you need to have a holistic, for want of a better word, approach.
Yes. Well, we would accept that that when it comes to mental illness, that those recognised forms of mental illness should also exempt. And my lords, perhaps we could just invite the board not to travel beyond the norm that's necessary to deal with the facts of this case. But I accept that an issue may arise on, for example, personality disorder.
Well, I was going to suggest that personality disorder has always been the huge problem for the criminal law in this area.
Yes, and they, of course, used to be called moral defectives.
It was exactly what used to be called moral defectives.
But if one's looking at that issue, well, all I can give you is the example of Canonier, which is a pretty interesting example, because there, appalling killing, he killed a police officer and then ordered the killing of the police officer, the witness in the police officer case, so and facing the death penalty. If one's looking at evolving standards of decency, a majority of the Eastern Caribbean Court of Appeal considered that a personality disorder arising from, as I've indicated, him having witnessed his father hanging himself when he was age 7 and subsequent was sufficient. In other words, it's not alien to the norms being developed at this moment in the Eastern Caribbean, Belize, and those other jurisdictions where there is a discretion, to say that there is an evolving norm, that if there is any significant recognised disability or disorder, that is a reason for not applying the death penalty. And that was a personality disorder case, which, as my lady has indicated, is the most difficult type of case. So we would submit that this that it may well be that a significant form of personality disorder should also qualify, but we needn't, if I can put it that way, cross that bridge necessarily at this stage. But we do say that and this is at 2 points, the underlying justification is that intellectual disability reduces mental responsibility. It reduces the ability of the offender to do justice to himself at trial and at the sentencing stage, renders the person so suffering less able to fit himself to undergo execution, and renders the execution a pitiful spectacle that is incompatible with human dignity. My lady, my lords, there are a number of rationales for the prohibition which are traced in the case of Ford and Wainwright, which we've analysed at 10, page 10 at 4.5. They are that the execution of such person offends humanity, that they are not capable of fitting themselves properly for the next world, that their execution serves no useful purpose, and that their execution is not retributively justified because of their lesser moral responsibility. Now, we would say that all of those, to a greater or less degree, would apply equally to someone suffering from mental, intellectual disability, what used to be described as.
We can't, I think, altogether leave out of our minds what the broader implications are by simply saying, well, all we're concerned with is this case.
Yeah.
And if it be the case that you couldn't morally or logically differentiate or block between intellectual impairment and other forms of mental abnormality, then one does come up against the question, how do you define it and where you draw the line? You talk about internationally accepted standards, but if you look at DSM-4, you've got a very wide range of conditions which may exist to a severe degree or a very relatively slight degree. How does one grapple with that in terms of a general principle?
Well, my lord, if that which is identical, well, the fundamental norm is, would it render it cruel or unusual to execute or to sentence to death? That's the underlying test. And if the board looks at those tests,
The trouble with that is that from the,
yeah,
depending on your starting point,
Yeah.
some might think that any execution would be cruel and unusual punishment. So it's very difficult, that.
well, my lord, that's prohibited under the Constitution because one has to assume that the death penalty is
I
itself.
understand that, but as an expression, it's easy to state the proposition, but it's not so easy to decide when.
Well, I appreciate that, but as it were, if I can put it, the weight of judgment weighs on the court. The fact that it's difficult, in our respect for submission, doesn't mean leave it to the legislature.
No, I understand
If
that. Does it, if you're right, does it mean that really in every, or in any case, after conviction of murder, if asked to do so, the judge must investigate really any mental or medical condition? If he's asked to consider and make up his own mind, as it were, case by case, would it be cruel and unusual punishment to carry out the mandatory sentence?
Provided it's a recognised form of mental disorder, I would say.
Nearly everything is, you see, Mr. Fitzgerald. That's the trouble. Nearly everything is. That's the trouble. If you look at DSM-4,
Yes.
you will find, for example, that intermittent explosive aggression is a medical condition.
Yes. Well,
So are eating disorders and sleep disorders.
yes. Yes, it does help where one has the notion of mental, of the ancestors or descendants of idiocy, to say, well, this is a well-recognised form of exemption to which this is an heir, or heiress. But in other words, that therefore it's legitimate to go to that step. But
I think there is some jurisprudence on this, is there not? There's some jurisprudence in the Privy Council on this question, on whether cases are the worst of the worst.
yes,
And I think that a number of authorities suggest that when that question is being addressed, and there is an issue about the mental capacity of the individual, that the court is obliged to have it thoroughly investigated.
oh yes, that's Petersburg and Robertshaw, which we've cited in the case. And my lord, yes, the Trimmingham.
I think
case,
there's more recent jurisprudence in people.
I think it's is it Max Tito? From
It is,
Holland?
yes.
Max Tito, yes. So that reaffirms that. Yes, absolutely, my lord. In the discretionary system, the board, following decisions of the Eastern Caribbean Court of Appeal has developed the principle of the worst and the rarest of the rare, but also said that you have to have regard to the personality of the offender, and effectively, on the ground it's developed that if there is any significant mental disorder, that will disapply the death penalty, provided it has some causative influence. And the two cases, Petersburg in Your Lordship's board, I think reinforced by Max Tydo, and the case of Mitcham in the East Caribbean Court of Appeal have said it's mandatory to have a psychiatric report. You must look into the personality of the offender. But what we're saying is that here there is, as it were, a time-honoured prohibition within which we can bring the appellants and the underlying justification we've tried to set out at 2.8 is that the intellectual disability reduces responsibility and the offender to do yourself justice and renders you less able to fit yourself to undergo execution, and also creates the pitiful spectacle. We have put in at 2.8 that in Guerin Baptiste, the board recognised a constitutionally protected right to have 72 hours notice so as to prepare oneself to face the ultimate ordeal and, if necessary, seek spiritual advice. We would submit that if that right has been recognised, it has by the board, if one's intellectually disabled, one would certainly be less able to avail oneself of that constitutional protection, to prepare oneself spiritually for this ultimate ordeal. And that was one of the reasons in Ford and Wainwright why the ban on the execution of the insane was said to be a fundamental principle of American constitutional law.
The same might be said of a wide number of anxiety disorders, mightn't it?
Yeah, my lord, it might, my lord, and I obviously don't want to indicate to submit before your lordships that other conditions are not covered. I'm simply submitting that this condition is definitely covered. My lord, so we would submit at 2.9 that the exemption of the intellectually disabled from the death penalty accords with the approach of both the UN bodies charged with the interpretation of the requirements of the ICCPR and the approach of the Inter-American Commission of Human Rights in its interpretation of the American Declaration of Human Rights. And we've set that out in the appellant's case at 24 to 36. And we then say that in determining where the line should actually be drawn in this particular regard, the relevant level of intellectual disability, it is respectfully submitted that the standards set by the US Supreme Court in the successive cases of Atkins and Hall provides the necessary guidance as to what evolving standards of decency now require. I'm not saying you have to savagely follow, I'm just saying that that's the carefully developed jurisprudence of the US Supreme Court is obviously highly relevant. My Lady, my Lords, at part 4, from page 9 onwards, we've referred to the basic common law prohibition, which is set out in the case. I don't think I need to take you through all those statements. Many of them have already been summarised by reference to the Atkins report. But Bracton, it's clear that mental illness included idiocy, which is the ancestor of mental retardation and now intellectual disability. So Bracton writes of the mentally retarded, the Latin word is infantulo, as coming within the exception. And Blackstone writes about the exclusion from execution of those who are idiots or are suffering from a total idiocy. If the board would wish to look at Bracton, volume 8, tab 138, just you can see that there. It's at page JB 3355. And one can see. Bracton at the end. This is about whether you're, as it were, if you're a felo de se, that's to say a suicide, whether you're held responsible, and because that was treated as a crime, of course, and one sees there at page 3355 at the bottom, it is submitted that he does not.
3 lines further back.
So what shall we say of a madman bereft of reason and of the deranged, the delirious, and the mentally retarded? So that's mentally retarded. And the word it's translating is sed de furiosa quid dicitur qui rationem non habet, et de mente capto, et de frenetico vel de infantilo. So it's the infantile, due to their being deprived of, their being mentally retarded. Or if one was labouring under a high fever. So a subsisting condition of mental deficiency was recognised as one of the grounds for exempting from responsibility and from execution from the start. And then one sees the whole history is set out in our case at EB 666 to 669. And you have the quote from Cook at paragraph 12, the quote from Sir John Hall's, it would be inconsistent with humanity at page 6668, paragraph 13, Hawkins at paragraph 14, Hale's pleas of the Crown at paragraph 15. They have not use of the understanding and act not as reasonable creatures, but their actions are in effect in the condition of brutes. And then over the page, Blackstone. And we just draw attention to the fact that he's saying in his commentaries that you shouldn't even pronounce judgment, pronounce sentence of death on them. So that's the ancient prohibition that we rely on as the starting point. And what we say at 4.3 is that the common law prohibition was given effect in both England and Wales and Trinidad throughout the century prior to independence in 1962. Those found to be suffering from insanity after conviction were simply not executed, and it was recognised it was wrong in principle to do so. The mechanisms were the judicial reprieve, which involved an actual judicial finding, the granting of a royal pardon, or medical certification, followed by mandatory commutation. And we've analysed that case, that history in the case, in the supplementary case. My lady, my lords, the US Supreme Court decisions, we say, are of some assistance. If I can briefly take you to Ford and Wainwright, that's at volume 1, tab 9, and volume 1, tab 9, that deals with those who are insane. In that case, it was by reason of mental illness, that's to say psychosis, and one has that in the at tab 6.
It's late onset, is it? It's after trial.
It's tab 9. Yes, it may be just
Must be,
may
yes.
just be
Case, yes.
Yeah.
it may just be detected afterwards, but it certainly in that case it was afterwards.
Looking
Yes.
at the head note, it looks that it came on afterwards. Yep, thank you.
Yes, and so well, quite helpfully, just in the opinion of the court, page 207 at the bottom, there's now little room for doubt the Eighth Amendment ban on cruel and unusual embraces at a minimum those modes of acts of punishment that had been considered cruel and unusual at the time the Bill of Rights was adopted. And then at page 208, moreover, the Eighth Amendment's prescriptions are not limited to those practices condemned by the common law in 1789, not bound by the sparing humanity of our forebears. The amendment also recognised the evolving standards of decency that mark the progress of a maturing society. And then it cites Blackstone, Cook, and then it says there are various rationales that have been given for the prohibition on the execution of the insane, and that's at the bottom of page 209. One explanation is the execution simply offends humanity. So that's, we would say, equally applicable to the execution of the intellectually disabled. Another, that it provides no example to others and thus contributes nothing to whatever deterrence value is intended. Other commentaries postulate religious underpinnings, that it is in uncharitable dispatch an offender into another world. And then it also said that execution serves no purpose in these cases because madness is its own punishment. So yes, that's solo furore punitor in Blackstone. And then more recent commentators opine that the community's quest for retribution is not served by the execution of an insane person, which has a lesser value than that of the crime which is to be punished. And so then unanimity of rationale, therefore, we do not find. But of whatever the reason of the law is, it is plain the law is so. Well, what we would respectfully submit is if one looks at those rationales, they all apply, we respectfully submit, with more or less effect to the case of the execution of someone suffering from mental impairment or intellectual disability. We just draw attention also to Justice Marshall's finding of the striking defect in the Florida statute at page 416, where he says, at the top of page 218, perhaps the most striking defect in the procedures of Florida statute, as noted earlier, is the state's placement of the decision wholly within the executive branch. Under this procedure, the person who appoints the experts and ultimately decides whether the state will be able to carry out sentence is long sought at the government, whose subordinates have been responsible for initiating every stage of the prosecution of the condemned from arrest through sentencing. The commander of the state's corps of prosecutors cannot be said to have the neutrality that is necessary for reliability in the fact-finding proceeding. And then, historically, delay of execution on account of insanity was not a matter of executive clemency, ex mandate regis, or judicial discretion. Rather, it was required ex necessitate legis. Thus, history affords no better basis than does logic for placing the final determination of a fact critical to the trigger of a constitutional limitation in the hands of the state's own chief executive. We would respectfully submit that that really is a principle that, given that the separation of powers is recognised as a fundamental principle in the Trinidad Constitution, applies equally here, that if there is a prohibition on the execution of the insane, and if at the time of sentence, whether by reason of supervening condition or by reason of the fact that it is first discovered or becomes manifest at that stage, it's plain that the person suffers from a degree of mental unsoundness that renders execution cruel and unusual. It must be for the judiciary to deal with it then, rather than authorising the imposition of a punishment which is cruel and unusual, because 5.2b says that you shall not authorise a punishment which is cruel and unusual. So it must be for the judiciary, not the executive. And in the old pre-independence position, where much was left to the executive, one can understand that it may have been left to the executive. But as a matter of principle, it cannot be right for a judge to pass a sentence which should not be carried out.
Did Fawn and Wainwright indicate what the Supreme Court understood was meant by insanity for the purpose of their ruling?
I think because it was conclusive there, I'm not sure that it does help on that issue, because he plainly was very, very ill, if I can put it that way. He was psychotic. But, my Lord, yes, well, you have the various psychiatric reports summarised at pages 205 to 206. My Lord, can I just check overnight whether there's any assistance on that? I think that because he was plainly severely mentally disordered, that issue wasn't gone into. One does have the dissent of Justice Rehnquist I don't think he throws any light on that other than let's create any other new procedural safeguards.
Now, I mean, one could see cases of significant psychotic disorder
Yes.
being recognisable as a class, but
Yes.
I don't know whether that's how they approached it or not.
No, they didn't. I don't think they gave an exclusive definition, but I think it was pretty plain that. Yeah, I think it's plain that he was in psychosis.
His condition is at page 204, and
Yes.
plainly florid.
Yeah, yes, no. I mean, he was florid psychosis. Yeah, there's no doubt about that.
Yes, but florid is often temporary, so
Can be.
Yes,
that's what it tends to mean.
yes. Well, it was paranoid schizophrenia in that case, but it's simply to look at the various rationales. But if we then move on to Atkins, I mean, that is mental disability. That's at volume 1, tab 6.
Yeah, that's intellectual deficiency.
Yes, and that's plainly our situation. And Atkins, firstly, well, I won't go through the total history of Atkins, but if I can just take the board to our summary of it at page 11 of the speaking note. If one asks why they found that the execution of the intellectually disabled is cruel and unusual punishment, the fundamental reason was it's contrary to evolving standards of decency and the dignity of human beings, but the detailed reasoning is, I hope, correctly summarised at page 11. Firstly, the court relied on consistency of the direction of change in state practice, and that is at pages 104 to 105. So one sees the changing legislative changes, Kentucky and Tennessee bringing in statutes similar to Georgia and Maryland, and then as did New Mexico, Arkansas, Colorado, Washington, Indiana, and Kansas, and then other legislatures are set out. And then at page 105, it is not so much the number of these states that is significant, but the consistency of the direction of change, given the well-known fact that anti-crime legislation is far more popular than legislation providing protection. The large number of states prohibiting the execution of mentally retarded persons provides powerful evidence that today our society views mentally retarded offenders as categorically less culpable than the average criminal. And then one sees at the bottom of the page, and it appears that even among those states that regularly execute offenders and have no prohibition with regard to mentally retarded, only 5 have executed offenders possessing a known IQ less than 70 since we decided Penry. The practice, therefore, has become truly unusual. It's fair to say that a national consensus has developed against it. Then the next point is that they then have to determine whether that is confirmed by their own objective analysis. And at page 318 at the top, one sees that they're looking at why this makes sense. As discussed above, clinical definitions of mental retardation require not only sub-average intellectual functioning, but also significant limitations in adaptive skills, such as communication, self-care, self-direction. Mentally retarded persons frequently...
I'm sorry, where are you?
Page 318 at the top, 108 at the bottom.
108.
108 in the electronic one.
Yeah, I heard the wrong thing.
Yes, as discussed above. And then mentally retarded frequently know the difference between right and wrong. Because of their impairment, however, by definition, they have diminished capacities to understand and process information, to communicate, abstract from mistakes, and learn from experience. There is no evidence that they are more likely to engage in criminal conduct than others, but there is abundant evidence that they often act on impulse rather than pursuant to a premeditated plan, and that in group settings they are followers rather than leaders. That rather echoes the point made by the psychologist in this case, that he would be apt to be a follower rather than a leader. And that was the prosecution psychologist. Their deficiencies do not warrant an exemption from criminal sanctions, but they do diminish their personal culpability. So that's the first ground, that lesser culpability, both in the view of the states, but also on the court's own objective analysis for the reasons set out at page 108 in the electronic bundle. Next, there was the court's own conclusion that the execution of the mentally retarded served the purpose of neither retribution nor deterrence. And that's in the electronic bundle at pages 109 to 110. And one sees, with respect to retribution, the interest in seeing the offender gets his just deserts. The severity of the appropriate punishment necessarily depends on the culpability of the offender. And they're saying that they are less capable by reason of the mentally retarded. If the culpability of the average motive is insufficient to justify the most extreme sanctions, the lesser culpability of the mentally retarded surely does not merit that form of retribution. And then with respect to deterrence, lower down, it seems like the capital punishment can serve as a deterrent only when murder is the result of premeditation and deliberation. As exempting the mentally retarded from that punishment will not affect the cold calculus that precedes the decision of other potential murderers. And then it goes on to deal with the theory of deterrence is not advanced. And one can see at the conclusion at page 110 in the electronic bundle, just before the break, thus executing the mentally retarded will not measurably further the goal of deterrence. And then there is another, so that it's both the changing consensus reflecting society's evolving norms and the fact that it won't advance the interests of retribution or deterrence. And then the further justification is put at the bottom of page 110. The reduced capacity of mentally retarded offenders provides a second justification for a categorical rule, making such offenders ineligible for the death penalty. The risk that the death penalty will be imposed in spite of factors which may call for a less severe penalty is enhanced, not only by the possibility of false confessions, but also by the lesser ability of mentally retarded defendants to make a persuasive showing of mitigation in the face of prosecutorial evidence of one or more aggravating factors. Of course, that does presume a discretionary sentencing system. But we would submit it's relevant in this case, where arguably we would submit the mental problems suffered by this appellant disenabled him from making the obvious points he could have made in his confession, which would have also carried over to any executive consideration. And then one sees at page 111 that our independent evaluation of the issue reveals no reason to disagree with the judgment of the legislatures that have recently addressed the matter and concluded that death is not a suitable punishment for a mentally retarded criminal. So it isn't just the state practice which may be unique to the US, it's quite plainly their own independent evaluation and their consideration of...
Gallia said that's all very well, but this is an opinion of the court, resting obviously upon nothing but the personal views of its members.
Yes.
Well, I think it was Chief Justice Rehnquist with whom Justice Scalia, no doubt, fervently agreed.
Yes.
Yeah.
Well,
He also had his own separate...
Did he?
yes, Scalia did, yes. Obviously, Justice Scalia's judgment makes is a forceful view and colourfully expressed, if I can put it that way, in his condemnation of the reasoning process. But the fact remains that the notion of lesser culpability is reflected in that century of commentaries. If one looks at the Royal Commission's report, the Atkins Committee's report, that there was a problem of lesser culpability, which did tend to lead to the disapplication of the death penalty. So we would submit that the judgment of the majority is of assistance. We would submit that, I'm not going to go into, if I may not go into Justice Scalia's judgment, but what he's effectively saying is this is introducing an unjustified new reason not to apply the death penalty based on a moral repugnance based on personal views. But if one analyses that judgment, that's not the case. It actually looks at the evidence, looks at the psychological condition, and looks at the underlying reasoning, and both in relation to diminished responsibility and in relation to the inability to cope as successfully at the trial and at sentencing stage, puts forward, we submit cogent reasons. Moreover, this, of course, chimes in with a growing international consensus. We do have a note on the duty of Trinidad to comply with the international obligations if the board would be assisted by it. But we have some, yes. But we have set it out in the case also. The detailed ins and outs of Trinidad signing and are analysed in that. But can I just put it very, very shortly? Trinidad is a signatory of the ICCPR, the UN International Convention. It's also a member of the Organization of American States, and therefore bound by its membership of the Organization of American States to respect the principles in the American Declaration of Human Rights. And those have been interpreted from time to time by the American Commission of Human Rights and the American Court of Human Rights. So we would submit that, as Lord Bingham found in Ray's and as has been found in other cases, there is a duty to have regard to the international law obligations of Trinidad. They are, as we submitted at page 12, relevant to the interpretation of the requirements of the Constitution, as well as to the interpretation of the common law. And there are certain points we'd respectfully highlight. Firstly, and this is at 5.2 of the speaking note, there are a series of resolutions, reports and decisions of the UN bodies and of the Special Rapporteur interpreting the ICCPR. And without taking you to the original sources, in 1989 and 1996, the Economic and Social Council laid down safeguards which include the elimination of the death penalty from people, and quote, suffering from mental retardation. So it's been extended from people who are insane to people suffering from mental retardation by the UN ECOSOC.
Is that in this most recent note, Mr. Fitzgerald?
No, this is in the speaking note and in the case.
Oh, in the speaking.
It's in the case, yes.
Yes, thank you very much.
So I'm on 5.2 of the case, but it's set out in detail in the case.
Yep,
I'm just highlighting certain points. And we've set that out in the case at paragraphs 27 and 28. Yep. Then in 2005, the UN Commission on Human Rights urged all states that still maintain the death penalty not to impose the death penalty on a person suffering from any mental or intellectual disability. We've set that out in the case at paragraph 31. And then finally, the UN Special Rapporteur has recorded in his report of 9th of August 2012 that the imposition and enforcement of the death penalty on persons with mental disabilities violates Article 7 of the Covenant. That's the prohibition on cruel and inhuman treatment, as well as Articles 1 and 16 of the Convention Against Torture. So we say all those authoritative statements are to the effect that the execution of the mentally retarded is prohibited and violates Article 7 of the ICCPR, which Trinidad and Tobago ratified in 1978. There is a further judgment of the UN Human Rights Committee in the case of RS and Trinidad to the effect that the reading of a death warrant to a mentally ill prisoner violated Article 7. And we've summarised that at paragraph 30 of the appellant's case. The decision of the Indian Supreme Court in Chauhan had to do with mental illness, but it's significant because they adopted the approach of looking at these UN resolutions, and they drew heavily on the same international materials we've cited in the case to reach the conclusion that the execution of persons suffering from mental illness was contrary to Article 21. That's the right to life under the Indian constitution. And it stated that civilized countries have not executed the death penalty on an insane person. We've set that out in the case, but we're just summarising it there. And then of course, Trinidad is a signatory of the OAS treaty and charter. As such, they're obliged to abide by the principles of the American Declaration of Human Rights. And in the case of Lackey and others, the Inter-American Commission held that the imposition of the death penalty on persons with mental disability is in violation of the rights recognised in Articles 1 and 2 of the American Declaration. I think it should, yes, and I think it may be 23. But in any event, those include the prohibition on cruel and unusual punishments. And that is significant because Trinidad and Tobago is a member of the OAS and is committed to uphold the principles of the American Declaration. Now, those points are all set out in more detail in the case, but we just sought to highlight the key points. We'd also commend respectfully to the board the decision of the Inter-American Court in Cadogan and Barbados. So that's the Inter-American Court rather than the Commission. And that held that there was a mandatory duty to obtain psychiatric reports in all capital cases where any question of mental disorder arose. Those basic, so we say if one looks at the past history of the common law prohibition, if one looks at the practice, the evolving practice over the 100 years before independence, and if one then looks at the norms established by the US Supreme Court and by both the UN bodies and the Inter-American Commission and Court, there is a virtual consensus that it is cruel and inhuman to impose or carry out the death penalty on those suffering from mental retardation or now intellectual disability. And we submit that, therefore, when one's deciding, does this prohibition apply at the sentencing stage, and is it within the terms of 5.2b, then as Lord Bingham indicated in Ray's, one has to have regard to international law obligations and to the practice, the developing practice of civilized countries, as the Indian Supreme Court said. And I mean, it's not really being said, well, it would be okay to execute someone who is suffering from intellectual disability. What appears to be being said was, well, leave it to the executive stage. Now, it was left to the executive stage, and what happened was he was read a death warrant after the pardon went through. And this is a depressingly familiar scenario where the argument is put, as it was put to the Privy Council in the cases of Fox and Ray's, leave it to the executive stage, it will all be sorted out there, and then it isn't sorted out there. And that's why we say, not just as a matter of fundamental principle, but as a matter of making rights practical and effective. If you leave it to the mercy stage, nothing will necessarily happen because there's no legal aid at all at the mercy stage. And to say, well, you can take a constitutional motion may be completely fanciful in the case of someone who is mentally retarded. So we do submit that there are reasons both of principle and actual practicality why the mandatory duty to inquire into these matters before sentence is imposed is an essential safeguard if the protection of rights is to be practical.
You say these matters should be resolved as a result of materials being put before the court and the court deciding at the sentencing stage.
I don't. That is essentially it. You can never rule out the long stop provision, but I do urge on the court, if one looks at the history, and the history is in many of these cases, until a mandatory duty to have psychiatric reports was introduced as a result of the death penalty becoming discretionary in the Eastern Caribbean, Belize and Bahamas, people were slipping through the net and being executed who had mental problems. A famous case of Mr. Shit, who was executed in St. Kitts, who, because he had nobody to plead for him and nobody to stand up for him and no political power, and was executed. And the moment he was executed, it was revealed that he was a person abandoned as an orphan in a lavatory as a child, and none of this had been brought to the attention or considered by the Mercy Committee. So we do respectfully submit that there really are reasons of fundamental principle, the separation of powers, but also of practicality, why these matters should be looked at at the sentencing stage. And we've, anyway, my lady and my lords, part 6, sorry, my lord, that was, yes, I've answered the question. Part 6, there is detailed analysis of statutory developments of the UK during the 19th and 20th centuries at paragraphs 43 to 63 of the appellant's case. I won't take the board to those other than to briefly summarise that there was, and it's analysed from paragraphs 43 onwards.
But you have been through this before.
Yes. Yes, okay, I won't.
You went out of turn.
Yes, okay,
no
yes,
doubt
yes.
Through my fault. But
I'm great. No, I'm grateful, my lady. Then you have the invariable practice. Can I just commend paragraph 63 where we, of the case, where we summarise the position in the light of everything, and that's really so. In the 2 centuries prior to abolition, the otherwise mandatory death provided for by the 1751 Act and later the 1820 sat alongside a longer-standing legal regime that prohibited execution where that would constitute cruel and unusual punishment. The judge, upon conviction, had a duty to inquire into the nature of any mental disorder. This could be done by postponing the pronouncement of sentence. That's under the 1751 and 1828 Acts, or without pronouncing sentence at all between 1836 and 1861. And then even after 1861, in every case where the court granted a reprieve, the Crown would exercise the prerogative of mercy and issue a pardon. So that's the summary.
Mr. Fitzgerald, supposing you're right so far, and that there is this principle deriving from common law and reinforced by emerging consensus, at some stage, are you going to deal with how it fits in with the partial defence of diminished responsibility?
Yes, my lord, we've
coming
to
to
that in the supplementary case. Well, my lord.
Don't worry, as long as you're coming to it, that's all that matters.
Yes, okay. Well,
there are two questions associated with it. One's procedural and the other's substantive. But you're coming to it, that's fine.
yes, well, my lord, it's set out in the supplementary case. Can I just give you the reference? From page 1084 onwards, in the supplementary case. It's electronic bundle, page 1084. Have you got a copy?
No, I do.
My lord,
Go on. Show whether off. Yes, got it. Thank you.
yes, well, my lord, happily summarise the position. What we say is that at the bottom of 1084, by introducing the defence of diminished responsibility, Parliament didn't remove or replace the prohibition on the execution of those whose unsound made it a cruel and unusual punishment, merely provided an additional and elective defence which could serve to reduce murder to manslaughter. Right. In fact, and then we make a number of submissions. Firstly, the common law prohibition, the execution operated side by side with the defence of diminished responsibility.
Yep.
See Archbold. Second, the 2 rules concern different questions. One, can you prove at trial that you're suffering from abnormality? Mm-hmm. One, what's your state at the time of sentence? Then the Royal Commission drew the same distinction in its 1953 report. That was about you don't run an insanity defence, or you do and you fail, where it was argued that that was an improper interference in the decision of the jury. The Royal Commission was quite clear that even where a defence of insanity had been rejected, that's 1086,
Yep.
the respite was a matter of duty, imperative duty, to respite, and you couldn't be inhibited by saying, well, the jury found the contrary.
Yep.
Thirdly, the underlying justification for the common law, the constitutional prohibition, is not limited to cases where mentally disordered individuals' responsibility is substantially diminished. Obviously, you might be well at the time of the offence but become ill later. That's not really the mental defect case. But secondly, the rationale for prohibiting the execution of such an individual is that it's contrary to the conception of human dignity. indeed the appellants submit the underlying rationale for the prohibition, is that it's an affront to human dignity to do so, and we've set out the Firman and Georgia principle. For reasons developed with the appellant's case, a consensus has emerged among democratic states that it is unacceptable to execute persons suffering intellectual disability. Then we say, in the case of those of unsound mind, at Roman 3, it's an affront to human dignity. And then at Roman 5, moreover, the justification for not sentencing to death is partly their accepted inability to do themselves full justice. That's the second justification in Atkin. Then fourth, at 2.7, it requires the accused, the defence, to prove on the balance of probabilities not only the existence of abnormality of mind, but substantial diminution. Yeah. If this board were to accept the Atkins approach, it would be presumptive that once you're intellectually disabled, it's wrong to impose the death penalty. And that echoes the Royal Commission saying that the diminution of responsibility may in borderline cases be relatively small, but can never be excluded. In our opinion, it would not ever be right to carry out the sentence of death in any case where a prisoner is certifiable as a mental defective.
In Atkins, the Supreme Court ducked the question, what level of intellectual deficiency makes the imposition of the death penalty cruel and unusual? And they ducked it again in Hall in Florida. Now, they were able to do that because it was a federal Supreme Court and they said this has to be worked out by the states individually. I don't think we could go that route. What is your answer to the question? What level of intellectual deficiency brings the principle into play?
Well, if it's a recognised intellectual disability involving an IQ of less than 70.
You see, that was what Florida adopted from Atkin and was then held in Hall in Florida to be wrong because they was adopting a cast-iron cut-off.
Yes.
But what if we are to lay down some rule which is going to be applied in Trinidad and Tobago? I mean, the trial judges are going to need assistance.
Yes, I would.
What it is they have to do.
Yes. Well, my lord, our initial answer is that if it's a recognised intellectual disability involving a less than 70 IQ, it passes the test. Then, as your lordship points out, there's the issue raised by the Florida case.
Because they recognise there is this thing known as SEM, standard error in measurement.
Yes. Well, my lord, there we would say that then it would be for the judge to determine, in those cases, whether it would be cruel and unusual, having regard to the fact that it's between 70 and 80.
I think we've got to do better.
Are you going to take us to Hall in Florida? Because you've mentioned it more than once. Are you taking us there?
Well, I'm happy to do so, my lady. Yes.
How are you getting on?
Well, I'm actually, at the moment, I'm trying to answer the question put by my Lord Hughes, but...
I know, but you had another question fired at you.
Yes, don't worry about diminished. I haven't found that particular part of your supplemental case. Whether it's right or not, your answer is quite clear. It's there.
Yes.
It's good enough for me.
Yes, so I'm sorry. Could we just... my lady, I'm sorry if I sounded under pressure, but can I just finish one point about... It's at 2.9, the fact that in Erskine, the Court of Appeal recognised this was an elective defence.
Yeah.
And
I've got
and therefore you cannot do it. And we've said in many cases, you make the election for the reasons that my Lord Toulson's identified, and you decide not to pursue it, but you are nonetheless either start staring mad or I mean, Erskine was such a case. He was suffering from florid schizophrenia, but he just decided not to run it. So it would be quite wrong to say that because he decided not to run it, therefore one can't look at it at the sentencing stage.
Your submission is that the court has to confront the fact of mental disability.
And we've given lots of examples. Winston Solomon.
I confess I was more interested, Mr. Fitzgerald, in whether the test for diminished shed any light on when, if you were right, the relevant threshold has been passed.
Yes.
It has the difficulty, if it were to, that you had the problem of supervening illness, so that may be the difference. But anyway, please don't worry about my question.
No, I'm so sorry. Well,
but what you do need to deal with is the suggestion that any recognised condition involving an IQ under 70 is enough. If there's an IQ under 70, I understood you to say that is a recognised medical condition.
yes, that's what we said. Yes, that's where the test. That's where.
In other words, under 70.
Yeah, under 70. That's
Enough.
it. Yes. And then the question is, but I know it may sound like ducking the issue to say, well, that's sufficient to deal with these cases, but that is our first point.
Yeah.
The second point we'd make is that in relation to the Florida case, which is in tab 1. It isn't in tab 1.
Tab 77.
It's tab volume.
Volume 4.
We have analysed that in the case, and all we would respectfully submit is that the tab 77, there's much reason in the Hall and Florida decision that if you're in that borderline situation, if it's really page 1793 in the e-bundle, at page 22 of internal pagination, Florida seeks to execute a man because he scored a 71 instead of 70 on an IQ test. Florida is one of just a few states to have this rigid rule. Florida's rule misconstrues the court statement in Atkins that intellectual disability is characterized by an IQ of approximately 70. Florida's rule is in direct opposition to the views of those who design, administer, and interpret the IQ. By failing to take into account the standard error of measurement, Florida's law not only contradicts the test's own design, but also bars an essential part of a sentencing court's inquiry. And then the death penalty is the gravest sentence our society may impose. Persons facing that most severe sanction must have a fair opportunity to show the Constitution prohibits their execution. And so they're effectively saying that if you're between 70 and 80 in the recognised margin, you should be able to put the case that you are nonetheless intellectually disabled.
Where does it say 70 and 80?
Well, it deals with the margin of error being set between 70 and 80. I'm so sorry, my lord. Yes.
I think two key passages in Hall, there's a bit at 1781 to 1782, and then at 1788.
I'm right. So one sees. Yes, the professionals who design and administer, this is 1781 in the last paragraph, is that the one?
Yes.
Yes, that IQ test scores should be read not as a single fixed number, but as a range. Each IQ test has a standard error of measurement. A test, SEM, is a statistical factor, a reflection of the inherent imprecision of the test. And an individual's IQ test score on any given may fluctuate for a variety of reasons. I'm just trying to find the bit where they say between 70 and 80 would be within the margin of error. Yes, they say 80 is outside the margin of error, so it must follow that between 70 and 80 is within the margin. And then really what... My Lord
But how do you test IQ? I mean, if you test a person's IQ every day in a week, you'd get a margin, would you?
Yeah, well, you sometimes do, and there's also this factor that if you've done the test many times, your scores may start to improve, which is a well-recognised factor, just by reason of the fact you've done it.
I think the nearest that it came in Atkin to a diagnostic definition was actually not in the judgment, but in a note to it, note 3, which they then actually go on to refer to in Hall at 1788.
Yes.
And one might expect the way it's put on page 1782, page 11,
Yes.
is generally considered to reflect a range
Yes.
between 66 and 76, with 95% confidence and so on. So
Yes.
it's a more nuanced.
Yes. Well, my Lord, we do accept that the reasoning in Hall and Florida would suggest that there is a kind of penumbra beyond 70 and beneath 80, where you should at least be allowed to put your case that you are nonetheless within the prohibition. And that is the approach adopted now by the US Supreme Court.
But they were able, because of their structure,
Yeah.
to say at 1788 that the states play a critical role in advancing protections and providing the court with information that contributes to understanding how intellectual disability should be measured and assessed. So they speak from Mount Olympus and then say the individual states can work it out.
Yes.
I don't think it would be very satisfactory for us to do that.
No. Well, my lord, I'm not encouraging the board to do so. But
I think the margin of error is dealt with at 1781 and 1782.
And 1784.
yes, well, it's the margin of error is, yes, at page 11, cannot be reduced to a single numerical score for purposes of most IQ means that it is best understood as a range. And then one sees a score of 71, for instance, generally considered to reflect a range between 66 and 76 with 95% confidence, and a range of 68.5 with 68% confidence. So I think the on their reasoning that is 80 that would be the absolute. I think Yes. Right. Yes. My name, my lords, what we'd say is that there should be a recognised diagnosis of mental disability, of intellectual disability. A score of under 70 would be a highly significant factor in determining that. But the diagnosis, the criteria for the diagnosis is set out in DSM 5, which we have at, is it volume 8?
It's volume 8. It's tab 13.
Yeah, yes, we have it volume 8 at
139.
139, thank you. Volume 8 at 139. And so there.
This is page 3367.
Page 3367, one sees diagnostic features. Yes, one sees halfway down, IQ test scores are approximation of conceptual functioning. So this is 3367. Yes, and then it deals with the fact that the level of social functioning, social judgment, and other the person's actually is comparable to that of individual with a lower IQ score. Yes. So, I mean, in one of the cases, I think it's in the case of Aspinall. No, it may be in the case of Ashley King. The person actually had an IQ of 89, but because of other factors, suggestibility and social functioning, a question arose of whether the person still suffered from a disability. But one can see that 70 is a highly significant finding. One could, by reason of lack of social functioning, even if above 70, be diagnosed medically as suffering from a mental, intellectual disability. So you have to look at both the IQ test and the intellectual functioning. But we would respectfully submit that if you are under 70, you should be treated as presumptively suffering from intellectual disability of a nature that justifies the disapplication of the death penalty. And then if we have to go further than that, I suppose the underlying question is it a mental disorder of a nature which makes it cruel and unusual punishment? And therefore one has to look at the tests of diminished responsibility, diminished ability to deal with the ultimate ordeal of the death penalty, etc. And you have to look at those tests on the basis of the individual that the court has before it. But we are advocating to the board that there should be, as it were, a red line, bright red line, that if you're under 70, it would be inappropriate in all cases to impose the death penalty. leaving it open that if you're between 70 and 80, there may well be other factors of of general social functioning that would bring you within the prohibition.
This is DSM-5, isn't it? Which you're doing. DSM-4 used to have, at its beginning, as it were, a health warning to the effect that these were convenient medical labels, helpful in comparing medical statistics and the like, but were not intended to provide the borders of any legal test.
Yes.
Is it there in DSM-5 as well? I expect it is.
I'm sure.
Right at the beginning it would have been, so you won't have it in this particular extract.
Yes.
But,
I'm sure it is,
Yeah.
but one can see. I mean,
Cautionary statement from
there is no doubt that that social functioning is an important part of the medical diagnosis, and that they would, and indeed one can see that the psychologists in these cases looked at the question of social functioning as well. So factors like the person saying at school he was slow, the aunt's evidence, all those matters would be taken into account, both pro and con. You have to look at the person holistically. But we are advocating that there would be a line drawn if one...
Well, where's the best material you have in support of that proposition?
Well, effectively, if one looks at the test in the later case, the Florida case, they're referring back to the fact that under 70 was regarded as the cut-off point. And they're saying that they misunderstood in saying that that's the absolute cut-off point. But certainly, it did follow from Atkins that if you were under 70, that would be enough. And so that's really... Yes. My learned friend rightly reminds me that as my lady drew our attention, that feeble-minded was under 70, so it was a recognised form of mental defect. The defect obviously had the range idiots, imbeciles, feeble-minded, but one of the recognised forms of mental defect was under 70.
But those were all defined by a definition in words.
Yes.
And it was just generally accepted.
Yes.
Because people were a bit more slavishly inclined to follow IQ tests in the olden days that aren't any longer, which is a slight problem.
Yeah.
But the actual legal definition was in relation to particular capacities that people had.
Yes.
Social capacities.
Well, my lady, it's only the desire to assist the board in formulating a cut-off point that we have identified that test of 70 as presumptive. But we accept that there may be other factors of social function.
Well, the nearest I think they got in Atkins in trying to identify what was the condition of which 70 was an indicator, is footnote 3 that they then went back to in Horwitz, which is on page 98 of the electronic internal, page 308.
Yes. I'm sorry. Is that in volume 1, or is that in...
It's Authorities 1, tab 6.
Yes.
In page 98, where they quote the American Association on Mental Retardation and the American Psychiatric Association.
Yes.
But those happen to be two American associations, and unsurprisingly, when it's a case before the US Supreme Court. But I don't know whether it'd be helpful to know whether you're putting something forward as an internationally recognised description of what one means by significant intellectual deficiency.
Yes. Well, it would be right to say that when the UN and the Organisation of American States bodies talk about mental retardations, they don't define what they're referring to. They don't. There isn't elucidation of exactly what level of mental retardation they're identifying. But we do submit that it is helpful make that starting point.
Could I just take you back to DSM-5?
Yes.
Mr. Fitzgerald, because immediately before 3367, bits of which you helpfully read to us, there are some tables starting at 336. Well, they need to start at 3363.
Yes.
With the subclassifications of mild, moderate, severe and profound at the bottom, and then there are descriptions of what is meant by each of those.
Yes.
In terms of conceptual ability, social functioning and practical daily living, effectively. Now, what I haven't traced is whether those are related at any point to the threshold of 70 that you're concentrating on.
Yes.
But I mean, is somebody with, if you read that mild intellectual developmental disability, if you read that, is that somebody who ought to benefit from the rule that you have been developing?
We would respectfully submit yes.
You would?
Yes, and I think that you would be mildly mentally retarded. That's the if you're up to 70.
So that would be within the rule?
Yes, you are.
How do we know that? I mean, this document doesn't actually relate them together, does it?
Well, what
So maybe, I just wonder whether we're in any position at all to say that we've conducted the kind of analysis which would make it possible to do what you'd like us to do. I mean, I can see it would be very helpful to the, it might make them rather cross, but it would make them, might be helpful to, I know, the courts of Timbuktu for us to do that. But it's quite a complicated question.
It is, my lord, but the Court of Appeal, and I have to recall that, the Court of Appeal in both these cases made a factual finding that the appellant suffered from mild retardation, arrested or retarded development of mind in the case of Pitman. That's a factual finding. And in the case of Hernandez, made a finding that on the uncontradicted evidence, he suffered from a learning disability characterised by the IQ. So it's not as if the local courts didn't make a finding of the level, that in both cases they recognised that it was a medically recognised form of retardation or intellectual disability. So we do say that that's not controversial. 69E of Pitman, and in the fact of a learning disability being diagnosed in the case of Hernandez. So that is a fixed point, a starting point. There's been a finding.
Yes, you've got that finding, but look at what's said about people with mild retardation on page 3364, if this is the right test, halfway down the box.
Yes.
In adults, abstract thinking, executive function, planning, strategizing, priority setting and cognitive flexibility, short-term memory and functional use of academic skills are impaired.
Yes.
Somewhat concrete approach to problems compared with age mates. Social domain, maybe middle of the page, difficulties regulating emotion and behaviour, difficulties noticed by peers in social situations, limited understanding of risk, social judgment, immature, and then lifestyle styles, talks about recreational skills. Now, is it your submission that somebody who falls into that sort of general description is somebody for whom it will, as it were, ipso facto, be cruel and unusual punishment?
Yes, my lord.
It will.
That is us.
Okay.
Yes, yes. And because there would be then both the diminished responsibility element, the lesser culpability, there would be the element of less able to fend for themselves, and less able to equip themselves to face what Graham Baptiste calls the ultimate ordeal. All those tests would be satisfied.
Okay.
Then, if that's the diagnostic and statistical manual, the ICD.
Well, I was going to say, what about the ICD-10?
3367 to
3372.
Okay, stop. Okay. 3376. One has, this is the, sorry, I'm so sorry.
That's rather different. Isn't it?
That's DSM 5. What the ICD 10 is 33. I see. So actually, if one goes to page 3376, that is in fact the ICD. It starts at 72, yes. So if one looks at page 3372, that's the starting point of the ICD. And then at 3376, one sees under mild mental retardation. However, this is about 10 lines down. Mildly retarded people can be greatly helped by education designed to develop their skills and compensate for their handicaps. Most of those in the higher range of mental are potentially capable of work. But one sees above that most of the ability to use speech to hold conversation. Most of them achieve full independence and self-care. And many have particular problems in reading and writing. And then one sees if there is also notable emotional and social immaturity, the consequence of the handicap, g.e. inability to cope with the demands of marriage or difficulty will be apparent. In general, the behavioural, emotional and social difficulties and the needs are more closely akin to those found in normal intelligence than to specific problems of moderate and severely retarded. An organic etiology is being identified in increasing proportions of patients. So there's the organic origin being identified. Yes, and then over the page, if the proper standardised IQ tests are used, the range 50 to 69 is indicative of mild retardation. Yeah. Understanding and use of language tends to be delayed to a varying degree, and executive speech problems that interfere with the development of independence may persist into adult life. So one does see there that in the ICD that they are indicating that 50 to 69, i.e. under 70, is indicative of mild retardation. So that may be helpful. And then they say an organic etiology is identifiable in only a minority of subjects. Associated conditions such as autism, epilepsy, conduct disorders are found in varying proportions. If such disorders are present, they should be coded independently. Includes, and then it makes feeble-mindedness, which is the old testing. So we would respectfully submit that if we draw back from it for a moment, the Court of Appeal regarded them as suffering from, both of these as suffering from an intellectual disability and a learning disability, respectively. They did find that this was within the internationally recognised test of mild retardation. And the Atkins case helps us on what the scientific literature tells one about those suffering from mild mental retardation, the reduction of responsibility and the lesser ability to perform and protect oneself in the criminal justice process, which we say is pervasive. And we say for all those reasons, if you do suffer from a recognised intellectual disability that comes within the test in the ICD and DSM of mild mental retardation or intellectual disability, then that is sufficient to presumptively disapply the death penalty. My lady, my lords, that's our primary submission. The alternative would be, and it is our, as it were, fallback position to say that the court should simply say that it is recognised in the literature and the case law that it can be cruel and unusual to execute someone who suffers from intellectual disability, and to leave it to the local courts, if I can put it that way, to determine in every case whether that is made out. That would be something closer to what happens in the discretionary system, where in effect, if there is any significant recognised disability, the courts on the ground locally are saying, well, that will be enough to say that it's not the rarest of the rare, it's not the worst of the worst, it's not a case where the death penalty should be imposed. And again, we're not reinventing the wheel wholly, because we do have 10 years of experience of how courts in the region operating the same basic common law approach, have approached the question of whether the death penalty is appropriate in cases where somebody suffers from a recognised mental disorder. And there's not a single case that I know of where there having been identified a significant form of mental disorder, the local courts in the exercise of their discretion, obviously subject to appeal to the Lordship's Board, have upheld the death penalty. I mean, and that's to say once either the board or the local courts identify a significant disability, it's held that the death penalty is inappropriate. So this isn't the case where we're asking the board to impose norms which are totally alien to the jurisprudence of the region. On the contrary, they're in harmony with the approach adopted in those cases where there is a discretion.
Well, I would have thought that you would want to argue that where the death penalty is mandatory, it's an a fortiori situation, because the purpose of the psychiatric examination in the discretionary life sentence is to determine whether there's any hope of rehabilitation.
Yes.
In the case of a mandatory life sentence, the purpose of the psychiatric examination is to see whether it would ever be appropriate to execute the individual concerned.
Yes. Yes, my lord, yes. Well,
if you're right so far, the impact on the present sentences depends, does it, on the proposition that the minimum term set is greater than it otherwise would have been because there was originally a death sentence.
That's it.
And is that, have you got any material which makes that out? What would have happened to these people for these killings on these, multiple killings on these sort of facts?
Oh, well,
in the absence, I suppose there are no statistics on that because it hardly happens.
No, my lord. What happens in the Eastern Caribbean is that where the death penalty is not selected, as it were, in the discretionary system, then they can impose and do impose a range of penalties varying from long fixed-term sentences to life in inappropriate cases. So far as I know, they never had life with a minimum term because it's questionable whether they can do that. But so we would submit that certainly if it was a discretionary life sentence, it would be without a minimum term.
Right.
Because the minimum terms in discretionary life as in England and Wales are a product of the 1991 Criminal Justice Act.
Yes,
before that, if you gave a discretionary life sentence, you could never say, and the minimum term will be X.
Well, it was possible to make a recommendation, wasn't it?
No, only in murder. Only in murder.
Yeah, in murder.
Yes, but yes. Yes, I'm thinking manslaughter terms. Yes, but not in murder on the basis of, sorry, my lord, you are one ahead of me. If it's murder on the basis of felony murder, I suppose, but that, yes, then, but I'm not sure that the Murder, Abolition, Death Penalty Act power to declare the minimum term that should be served is replicated in the Trinidad legislation. We will check that overnight.
What's the process in Trinidad and Tobago for dealing with prerogative of mercy? One knows that it's a matter for the executive, but how did it operate in practice?
Well, what you'd have to do is, I mean, the Mercy Board, if I can call it that, it's comprised of the Attorney General, a minister and various others. I think there may be a judicial member, but what the Attorney General is ex officio a member. So the person is the same thing as identified in Ford and Wainwright. A member of the executive that's been prosecuting you is on the Mercy Board. And what they then do is meet and consider whether to commute the death penalty. The principles in Neville Lewis would, although it's a Jamaican case, would probably apply. That's to say that if you want to put in representations, they'd have to consider them.
Right.
But there's no hearing, obviously. There is no elaborated duty to notify you of anything that they have before them. And if we want to have an example, Pitman, he couldn't have got to the stage of having the warrant read to him without having
But if they refuse, are they required to state reasons?
No. And indeed, in Neville Lewis, even your Lordship's board, in that case, said that there was no duty to give reasons. There was a duty to give fair consideration to representations, but not an absolute duty to give reasons. So, and that was in Jamaica. So I don't think it's established that there's a duty to give.
Did they give any reasons as to why they shouldn't have to give reasons?
They just said not yet. They didn't rule it out. They just said they were not going to go that far. I think. But my lord, I'm doing Neville Lewis from memory. But I think it's right that there's a duty of fairness to allow you to make informed representations.
I mean, given the difficulties of drawing hard and fast lines, I can see some possible attraction in a system which provides a defence of diminished responsibility and requires that after conviction there have to be medical reports, etc., and it has to be considered by a board which provides an opportunity for representations to be made properly and is required to give its reasons so that they can be examined and subjected to legal review. But that doesn't fit with what you've got at the moment.
No. And well, my lord, the objection in principle to your lordship's solution is in the Ray's case, where Lord Bingham looked at the question of does the prerogative of mercy provide a satisfactory safeguard, and said it didn't. And that's at the very end of the judgment in Ray's.
Yes, but they were looking at a different set of facts.
All right. Well, my lord, can I just give you these reasons why? Firstly, the prerogative of mercy, there's no evidence of it ever having worked successfully. Secondly...
What do you mean it's never exercised in favour of the...
well, on the delay cases it is, yes.
Sounds as if it's exercised nearly all the time.
Sorry?
Sounds as if it's exercised nearly all the time.
In all the delay cases, it is. No, most of them are in limbo.
Oh, I
They've
see.
neither been commuted nor
Yeah, that's
executed.
right. And
Most
in
of
fact,
them are in limbo.
we've got
There have
cases
been-
which are complaining about the limbo.
There have been wholesale commutations, one by the order of your lordship's board after the case of Matthew, because the people as a result of the Rudolph decision, were told you're going to have a discretionary, and then they didn't have a discretionary. So there was a wholesale commutation. There have been wholesale commutations of those more than 5 years.
Right.
Yeah.
But in terms of you, because of your special circumstances, we're going to commute because you've used, other than the Matthew case and the delay case, I certainly don't know of any, and maybe we can check about that, where they've said because of some special medical factor, and they tend to just be in limbo. But there is no at present. There's no notification. The Mercy Committee will sit next Monday, put in your representations. There's no disclosure of the materials that will be before the Mercy Committee. There is no oral hearing before the Mercy Committee. There's no provision for representation or legal aid to get representation before the Mercy Committee. There's no duty to give reasons. And obviously, if you don't have legal aid, you don't have a state-funded psychiatric report. Effectively, we say, and the last person to be executed was a domestic... Well, he was a domestic killer. Yeah, the last person to be executed was Briggs, who was a domestic killer. So it obviously didn't work very well for him. The mercy. I'm not saying domestic killing is not serious, but the fact is, if there were a discriminating system, one would have expected him to benefit from that. So
we say that we don't know anything about the facts.
no, well, okay, all right. Well, mine was sorry.
Well, we're going down a lot of byways.
Yes. No, well, no, but I'm sorry, my lady. Yes.
No, it's not your fault.
Okay. Well, can I then just race on through page 16 of the sorry, would your lordship forgive me then if that
I think you better get on.
Yeah, what?
I think you better get
Yes,
on.
I better get on. Yes, page 16. Then statutory provisions for the death penalty in Trinidad. You have, where we've set them out there, every person convicted of murder shall suffer death. We've set out what we say it should have been interpreted as, save in so far as that would constitute cruel and unusual punishment by reason of unsoundness of mind. That's as it were, what it should have been read as all along. And then we say if you go back to the predecessor in 1842, shall suffer death as a felon, it couldn't have been given a literal interpretation since the common law accepted pregnant women and the insane from execution. And there had become a stage fairly in the 19th century where if you were reprieved on grounds of pregnancy, you were never executed. That's in the Royal Commission. Then it wasn't put on a statutory footing until 1932, but before that, we say it couldn't have been literally read. So the exception advocated by the appellants at 7.4 has always had to be read in to reflect the proper state of the law. Then we say it's significant that there is no express duty to pronounce sentence. In the 1861 Offences Against the Person Act, which you have at volume 3, tab 60, at page 977, there is a provision under the English procedure that you must pronounce sentence. But we would say you can only imply a duty to pronounce sentence into the Trinidad statutory language subject to the exception, where no common law or statutory exception applies to make it wrong to pronounce the sentence of death. So summing up, we say there's always a duty to give effect to the prohibition on execution of the mentally unsound in Trinidad. The appropriate mechanism in the past would have been either not to pronounce the sentence at all, but record it, or to pronounce the sentence but grant a judicial reprieve. Perhaps that's the most common form reflected in the history, and we've set that out at paragraphs 67 to 70 of the appellant's case. But we say that there's no doubt that the appropriate mechanism now must include a judicial determination that avoids the judge passing a sentence that can never lawfully be carried out. We've summarised our position on the 62 and 72 constitutions at page 18. We say it would have been contrary from 1962 onwards to impose or authorise the imposition of cruel or unusual punishment, and the sentencing to death of someone who is manifestly of unsound mind would have violated that prohibition. The objection that nobody ever took this point is fully met by the reasoning of the board in Bow, we refer you to what Lord Bingham says, because in Bow it was said, well, Lord Bingham and the board found that the death penalty would have been struck down in 1962, but not by a process of historical imagination, but what the law should have been declared had the challenge been presented then. And we do say that's important to the argument or the fear lurking in the back of the mind. Well, that challenge was never taken. Then under the 1976 Constitution, we said that the sentencing to death of a person suffering from intellectual disability would violate the prohibition of cruel and unusual punishments in section 5.2b of the Constitution, and it would violate the right not to be deprived of life, save by due process of law, enshrined in section 4a. Finally, to permit the sentence of death to be pronounced on an intellectually disabled person and leave it to the executive to grant a reprieve would violate the principle of the separation of powers. And the savings clause, I really dealt with.
You've dealt with.
Yes, so we dealt with Matthew. Yeah. It doesn't invalidate, so that's at 8.4 and 8.5. I've dealt with the separation of powers principle. This is just a further elaboration of it. The criticism of the Court of Appeal's approach, that really is set out in the case, and we respectfully invite the board to see the...
Well, if you're right, they're wrong.
Yes, I don't think, yes, the detail. It's simply we respond to the argument this should be left to the legislature. If it's a matter of constitutional imperative, it can't be left to the legislature. And again, Lord Bingham dealt with all these kind of points in Rays. Then we say that the sentencing process was unlawful. Again, if we're right that you should read in, except where they're suffering from mental unsoundness, and that's capable of evolution, then the sentencing process was unlawful, even if nobody asked for that process. The appropriate remedy, we do stress the point, which is at 12.4, that the power of modification under Section 5.1 of the Constitution Act is extensive. You have that in Volume 1, the power of modification, and that is the power that was used in the mandatory cases, there is authority that it's a very extensive power to modify existing laws so as to bring them into conformity with the Constitution. So what would be needed would be obviously to provide an alternative sentencing. The prohibition is already there. You can't sentence to death if the person is mentally unsound, but the need for the court to be empowered to pass an alternative sentence in lieu can certainly be provided by a modification of existing laws if the court has the power under section 5.1 to say from now on detention during the state's pleasure will be detention during the court's pleasure, and effectively put the courts in charge of something which had traditionally been done by the executive, including the review of the case. Then there's no doubt that this once and for all exercise could be done by the courts rather than left to the executive. And then we do just, to the supplementary case, can I just indicate to the court that in the supplementary case we deal in some detail, this is at page 1082, with the argument about the introduction of a defence of diminished responsibility. So that's at part 2, from 1084 to 1090, and why the introduction of the defence of diminished responsibility does not take away the judicial duty not to impose a sentence whose carrying out would be cruel and unusual punishment. And can I just draw the board's attention to the one part I didn't deal with, which is page 1089, 2.9, about the consequences of it being an elective defence, and the election is either not exercised for tactical reasons or more typically because the resources aren't available to explore diminished, which is at Roman 3. Yeah. And then we've dealt variously at part 3 with the argument that common law prohibition applies only to the execution of persons of unsigned, not the pronouncement of the sentence, and sought to show that the judicial reprieve did involve a judicial determination of whether the person suffered from unsoundness of mind. So this is not inimical to the approach of the common law for there to be such a determination. And then at part 4, page 1093, the argument that any prohibition on the pronouncement of sentence of death was repealed by the 1842 ordinance. We say that the 1842 ordinance was always subject to the exception that we've urged on the board. At part 5, wrong to develop the common law prohibition to cover those with intellectual disability. We say there's no inhibition on that by reason of the introduction of diminished responsibility. And then over the page at 1095, the common law prohibition cannot be taken away except by the most clear and express provisions. There's nothing in the 1985 Act introducing diminished responsibility saying, and from henceforth there will be no consideration of whether mental disability or some mental abnormality justifies the disapplication of the death penalty. And indeed, the 85 Act isn't death penalty specific. It would continue to exist even if the death penalty were abolished, as has happened in England and Wales. And then the point that my learned friend makes, with it's all very difficult and therefore leave it to the legislature, we respectfully submit that is not the approach which the constitutional imperatives of interpreting whether 5.2b has been complied with demands. The same arguments were put in Rays and in Fox. The same arguments were rejected. You can't leave it to the legislature if you leave the courts imposing a sentence which is cruel and unusual. And then on the sentencing process and appropriate remedy, we've set out at part 7. And then we've dealt with the point that it can't just be saying, could you give us some delay in case we can think up some point, that was the ground for the reprieve. That when the judge granted a reprieve on grounds of insanity, there was a duty on the Crown to grant a royal pardon, or certainly it was granted as a matter of course. My lady, that's really the sum of the points we make in the reply, and with.
Well, it's not your fault, Mr. Fitzgerald, but you are way over your time.
By 10 minutes.
Yes, that's way over your time.
I do apologise, my lady.
And you know, if you were in,
12 minutes.
yes, if you were in the Supreme Court of the United States, you'd have stopped talking a long, long time ago.
I'm sorry,
But it's
my
not
lady.
that we don't like listening to you. Very far from it. This is a really serious and difficult case. Please do not think. I hope nobody in court thinks that because there has been a certain amount of smiling and even sometimes laughter in the court, we don't think that this is one of the most serious cases that we have had to consider in this board for some considerable time. I believe that we're sitting at 10 o'clock tomorrow morning. I hope it will be.
Do you mind if I just ask one thing for tomorrow?
Yes, of course.
I'm afraid I plead guilty to having prolonged things already, Mr. Fitzgerald, but it occurs to me that one of the things we probably shall need to know tomorrow is what the parole system is in Trinidad, and whether it applies to life sentences.
Oh, yes, it does. Yes,
Yeah, there must be one. It's
yes.
We need to know what it is.
And they would be.
How it works.
Yes, my lord, we will. Okay. Yes, we'll try and put that in a note overnight, and we'll.
Well, that's asking more than I ask.
Yes.
Oh, okay.
Yes.
Well, if you give me 5 minutes tomorrow, I'll tell you about something.
Well, I was wondering whether it would be appropriate to ask Mr. Bowen if he had anything to add to your observations, either now or tomorrow morning.
I've nothing to add. I'm very grateful, though, my lady.
Well, we'll look forward to hearing from you all at 10 o'clock tomorrow morning.